Law Conference 2021. We will now begin session 4, recognizing Muslim divorces worldwide. What are the considerations at play? You see, the practice of Sharia family law has changed with time, with more international marriages being seen among Muslims. In this session, the panel of experienced Muslim law practitioners from Singapore and from the United Kingdom will explore how complex issues arising in cross-border, cross-cultural Muslim marriages would be dealt with in the two jurisdictions and in the respective Asian and European regions, including whether and how such marriages are recognized, the jurisdictional requirements for the courts to hear divorce proceedings in such marriages, and perhaps such as very much more importantly, how financial matters and child-related issues will be determined. Your panelists for this session will be Aina Khan, OBE of Aina Khan Law, England, and Ahmad Nizam Abbas, Senior Partner of Emerald Law, Singapore. And this session will be moderated by Halijah Muhammad of Halijah Muhammad & Co. Just as a reminder to all of you, questions regarding this session can be submitted through the MicePad platform Q&A function. So ladies and gentlemen, Halijah, your panel.
Thank you, Darren. Welcome everybody to the second last segment of the conference today. I know it's been a long day and we will try to be as entertaining as possible. We try. Yeah. So today we will forego the more common presentation style of a lecture, and instead I will be shuttling to and fro between Aina and Ahmad Nizam to try and engage in a dialogue about this topic. Yeah. So let's jump into it. Yeah. So we will start with some basic information because it's necessary, yeah, before jumping into the issue of recognition of foreign divorce, to understand the context, yeah, of how Muslim personal law operates, yeah, in each country, and in this case, obviously, it's Singapore and UK. So I will start now with Ahmad Nizam, and we're going to start with the architecture, yeah, as Minister this morning said, or the legal and judicial framework of how Muslim law operates in Singapore. Nizam. And I've just told Nizam that my challenge with Nizam is this: it's hard to shut him up at times because he loves hearing his own voice and he does go on and on. So Nizam, do please keep to the time slot. Yeah, Nizam.
Right. Can I plead for natural justice here that do not please judge me? I haven't even started, and you really got judgment on me.
Granting, Nizam. Yeah.
Okay. But I thank you to Law Society and all the rest for inviting us. And I have to say a special thank you to Minister Edwin Tong this morning, because he actually gave some background to how Muslim law came about in Singapore. So what I'll do is that I'll just add on to what Minister Edwin Tong said this morning, right? And it's important to remember this. He said that in 1826, with the enactment of the Second Charter of Justice, right, even with the enactment of the Second Charter, where the common law of England was imported or made applicable in Singapore, what remained was that the locals were allowed to continue with the religion, the manners, and the customs. Now, what is important to remember, therefore, is this: even before Stafford Raffles stepped foot onto Singapore, Muslim law was already practiced in Singapore. For lovers of legal history, you can read up Professor Ahmad Ibrahim's, he's got a whole tome of literature on this, of the legal history of Muslim personal laws in Singapore. But he will explain, or he has explained in his books, right, how the entire region practiced Muslim law. And that is why if you look at the Administration of Muslim Law Act, you will find certain wordings which say that Muslims in Singapore, right, will be can apply Muslim law as modified by Malay customs. Because if there's Malaysia, there's Indonesia, and other parts of the region where the Muslim laws have been influenced by the local customs. But let's move forward. And moving forward, the first legislation was in 1880 with the Muhammadan Muslim Ordinance. And this is where the registration of Muslim marriages actually started, because Qadis, and these like local leaders, religious leaders, they were empowered to record, right, the registration of marriages, which then had to be given to the governor's office. So they were appointed by the state. Then we move fast forward again to another date, which Minister Edwin Tong mentioned, 1957. That was the year the Muslim ordinance was enacted. It repealed the old MMO and just became MO. Now, what's important about 1957? The creation of Sharia Court. So, why was it necessary? It's because it formalized a very loose system. So in the past, yes, there was registration, but they were done by Qadis. And these are like the religious elderly, in the villages. You go up and say, I want to marry XYZ. And okay, you go through the ceremony, and then he just puts in a register book. But the problem was that when parties got divorced, there was no court. So they went back to the same Qadi, and the Qadi will say, okay, now you're divorced. But because the Qadi couldn't make any orders on the house and everything, he left it to them. Do you agree what to do with the maintenance, what to do with the house? If they agree, you record. If you don't agree, that's it. They were left in limbo. So 1957, the Sharia Court was created. Then we fast forward, because in 1965, Singapore became independent, and one of the first acts of parliament to be debated was the AMLA, Administration of Muslim Law Act. It was a very powerful act in the sense that it needed an entire parliamentary select committee to be enacted and then debated as to what were the powers given. Long story, but I'll cut it short, is this. Out of the 1966 AMLA, what do we get? Three important things, right? One, the institutionalization of the Sharia Court. The powers were made clearer. Then you have the registry of Muslim marriages, and then you have MUIS. MUIS is the Islamic Religious Council of Singapore, but their job is not part of our purpose today, because they advise the government and the President of Singapore on matters of Muslim law. The Sharia Court is important for our purposes today because that's where you go to for divorces. So over time, the Sharia Court has evolved, and each time it does that, it's usually through acts of parliament. So roughly every 10 years, there will be major amendments in parliament, and because it's always instead of evolution, mistakes or gaps have been closed, improvements made. So you see that in 1998 and 2008, major amendments were made to the AMLA. So now you have a very, a much more refined system compared to back in 1957. And you see that the Sharia Court now handles matters involving divorces, and they have gone into cross-border issues, and we have imported expertise from the Family Justice Court into the Sharia Court with experiences that they have gained from there, and which now they impart or they share at the Sharia Court. But just a note before Khalida gives me the cut-off is this. Even though I said that Muslims, you go to Sharia Court for divorces, that's not to say that the Women's Charter does not apply to them. The Women's Charter is applicable to Muslims. So in terms of protection orders, maintenance during marriage, even maintenance after marriage for children, the Muslims still go to the Family Justice Court. The easiest way to remember is that the Women's Charter applies to all, including Muslims, but where there are express legislation to say that those are exclusively for the Muslims in Singapore, then the civil courts do not have jurisdiction. Okay, Halida, that's it.
Thank you, Ahmad, for keeping to the time. Aina, you've heard that the framework in Singapore is that there is a formal legal structure for operation of Muslim personal laws, with legislative provisions, the Administrative of Muslim Law Act, with specific institutions like the Registry of Muslim Marriages, and of course the Sharia Court, where Muslims go to get a divorce. I wonder whether we have a similar framework in UK, because as I understand it, the UK system is a unitary system. Yeah, there's only one legal system for personal laws, regardless of religious affiliation. However, I understand that there are organizations lurking, for want of a better word, yeah, like the Islamic Sharia Council, like the Islamic Arbitration Tribunal, and these entities, they actually solemnize Muslim marriages, and they actually officiate Muslim divorces. Now, in that unitary framework, legal framework in UK, what is the legal status of these entities or religious authorities?
Thank you so much, Halija and Ahmed. It's an honor to be invited to be here. And I can tell you now, you'll all be shocked to hear, there is no such formal structure in the UK. We have one law for all, as you say, and the government has chosen to ignore the 3.3 million Muslims and growing, roughly, and many other minorities. So Hindu, Sikh, everybody has just been left to have a free-for-all. The law is still stuck in 1949, pre-mass migration, in the 50s, 60s, 70s. We have chaos. We have a law which is not fit for purpose. And the human rights abuses this causes are absolutely horrendous. You'll be shocked to hear that you, in 1880, in Singapore, were a world apart from us in 21st century UK. Why do I say something that damning? Because I have a campaign that I started called Register Our Marriage, because I feel so strongly that the government has to wake up and give them credit. They have listened to the campaign and they have funded a series of road shows around the country, a website, social media to raise awareness. So I've got one prong of the work done. The other prong is to get the legislation updated. I want parity for all faiths in the UK. Would you believe at the moment only 3 faiths have to register their marriages? So Christians, Jews, and a minority called Quaker. Nobody else has to register because the law doesn't think it's necessary to catch up. We've had many, many reforms of marriage law, roughly every 10 years. They've opened up the framework, allowed mosques to register to perform marriages and become authorized places for worship and performance of marriage. So that's fine. They assumed that all the mosques would listen and comply and everything would be fine. I had to look and get research commissioned by Channel 4, a TV program which followed my campaign, to prove none of this happened. Hardly 1 in 10 mosques are legally registered to conduct marriages. The Sharia Councils, which you may call courts, but do not do that, please, because there is no way that we could give them recognition. They are quasi-legal. They have no enforcement powers. So to call themselves judges is wrong. It gives them power in the community's eyes, which they shouldn't have. And it's really, really important that we realize that the average Muslim person, along with everybody else, doesn't realize any of the law. They're happily getting married, divorced, remarried in a wrong way. So they don't even know the status of their own marriages, let alone financial rights. So, for example, they assume by living together, we have legal rights. So it doesn't matter if we're not legally married, we'll have cohabitation rights. We don't have that in England. So you have 0 rights. You're still a girlfriend in English law. After 30 years, you can find that out. Huge shock and devastating for many. Now, you might want to know, what is the impact? For example, repercussions in a few examples would be for you to know. Could you believe that you could be in England, be a Muslim couple, you could get married orally? There's no requirement for a marriage certificate even. So you don't have anything to prove that you were married. You could be begging the imam who conducted the marriage to give you the certificate and they'll refuse. Happens all the time. You could be divorced orally or in a WhatsApp. You're lucky if it's a WhatsApp. I say, thank God. Be grateful. I know you're devastated, but at least it's in writing. Because orally, hundreds of thousands of women are actually being unilaterally divorced under a talaq. Okay? And if you look at the fact that this impacts on children as well, not just a couple, but on innocent children, it's absolutely unthinkable under a justice system that is allowed to happen and perpetuate. It means you can be made homeless overnight, the husband dies, and the in-laws take the house and say, that's our property. We don't recognize your marriage and the 4 children. Overnight, you're evicted. No pension rights. That's just if it was a happy marriage. And then if you have a bad marriage and it breaks down, it's absolutely free for all. You're completely dependent on Allah, because people say that, I'm dependent on Allah, He will do justice. But Allah says, tie your camel. There's a saying, you don't let the camel wander around. So you have a duty to register your marriage. And I've been educating men who've cried in front of me, who've been taken for a ride, all their savings taken, house bought and then thrown out because there's no matrimonial home. And women, of course, who are horrified to find, why didn't they protect me? They think the government, they call them they, there's somebody out there who will protect me, let me down. That is correct. I do agree. The judges have been very cruel in many ways in the case law over the last 10 years, which considered Muslim marriage. There's a raft of cases. They've actually said sometimes things like, you're an intelligent woman. You should have known better. Why did you allow this to happen? They allow polygamy, rampant polygamy, because none of these marriages have any status. It's not bigamy, it's just a girlfriend upon girlfriend. So polygamy is rife as well and growing.
So
you can see I'm very passionate about this.
I know. Can I just understand this, right? So in UK, right, a first world rules-based society, you are saying that for Muslim marriages, they can undergo the Islamic rites, yeah? They go to the mosque, they go to the Sharia Council, they have their marriage solemnized at home, and there is no legal requirement for this marriage to be registered, and because it's a unitary system, right? There's no requirement for this Muslim marriage to be registered in the civil marriage registry. So no legal requirement.
So first of all, very important to know, the Sharia Councils that were formed in the early 80s by ijma, consensus, was a very good service to the community, to these women who were chained in limping marriages. So it started with a very good civil justice framework, because there was nothing else in civil law. But then what happens is they become too powerful. And they have huge influence all over the community, untrammeled. There is nothing to curb their powers. They don't usually do registration of marriage, however. They tend to not get involved in that. Some of them, in the bookshop or secret little front room, do whatever they like. And they've grown from 2 leading ones to about 80 plus that we can trace. Everyone, I can set one up tonight in my front room. Nobody will care. But they don't usually get involved in the marriage. They get involved in divorces. So khula, divorce, fasq, which is the nullity. So khula is a women's right of divorce, unilaterally to say, I want a divorce. I'm not going to give court-based grounds. I just will give up my financial settlement, meher, and I want to be freed. They usually do that. They make you give up the financial settlement that is your right under marriage, and then you can walk free. They sometimes give fasq, which is a nullity, to say that it never existed, this marriage. And I've actually been training them to give tafriq, which is the judicial divorce, Because I've been saying, why are you making women give up their rights? This is fault-based divorce. If it's his fault, let her keep her meher. And to be fair, one or two of them have agreed to do that.
I know.
I've got a point. Yeah, carry on.
Sorry to interrupt. Can I get back again to this system of registering or not registering Muslim
Yes.
marriages in UK? So there are that category of people that undergo Muslim marriage and choose, for whatever reasons, lack of awareness, etc., choose not to register their marriage in the civil marriage registry. And then there is, as I understand it, because I've done some cases where UK national Muslim parties, they come to Singapore, they work here, and then the marriage fell apart, and then they want to get a divorce here, and I have to scrutinize the what sort of marriage, whether there's any official document. So I understand that there is a second category of Muslim marriages where they actually undergo Muslim Islamic marriage rites. And they chose, and cleverly and rightly, to register the marriage in the civil marriage registry. So I suppose for that category of people, the rights and obligations flowing from the marriage are there. And then, as I understand it, there is a third category where they are Muslims, but they choose not to go through the Muslim marriage rights, and they just register the marriage in the civil marriage registry. And I assume...
Okay, so
yeah.
Let's work backwards then. Hardly anyone that I know nobody who just has a civil marriage and doesn't have religious. It's unheard of.
Mm-hmm.
So if you found me one, I'd be very interested. Usually there's some kind of oral nikah somewhere. Even if there's no paperwork, even if they're pretending to you it never happened, you'll find there'll be a photo somewhere or a video of some ceremony, okay? It just means it didn't register in a mosque on a piece of paper, that's all.
So just a few other things about marriages in UK. So given that there is this informal, right, out of the court system structure, right, where they have Muslim marriages, is there any legal requirements? Yeah, for example, is there a minimum age of marriage? You know, you can't be married when you're like 14 years old or 15 years old. Or is there any requirement of consent from both bride and groom?
So first of all, nothing, because they don't recognize that this happens. When we talk to them, they did, for example, Sharia review. The Home Office did do a Sharia review and gathered knowledge. And when the Sharia review recommended that we must have regulation of Sharia Councils, the government's view was, no, it doesn't exist. We don't even recognize Sharia law, so why should we review it? Why should we regulate it? Why should we codify it? Okay? They did listen to the two-pronged approach that I've been saying, which is raise awareness of the repercussions and change the law. So some of it the government's listened to, some of it they haven't. The very key point I want to bring home to all of you is this only a few people? You're probably all thinking, yes, okay, it's a few people, so what? My research shows an anecdotal evidence that is over 80% of marriages that are not legally registered, much more in some communities. Somali, Bangladeshi, maybe 95% plus. So it depends on, if it's a very small community, sometimes they're well regulated, like the Ismaili Shias. They're very structured, but others are not, okay? That means that the government never codified anything. You can have underage marriage, you can have unlimited marriage. People are marrying 5, 6 times, not keeping track of the number of wives. Anything goes, basically. Nobody is caring. And that means if it's 80% plus of 3.3 million Muslims plus, you can do the math and find out it's a horrific problem, isn't it? Yeah. And another thing you should know about the demographic, it affects young people much more than older people. So the younger you are, the more likely you are to be a victim to this.
I will have to stop you on this topic because I need to ask Nizam, right? Having heard quite this horrifying scenario in a first world country, right? Like UK. Maybe Nizam, you can talk a little bit about marriage in Singapore, and I suppose we should be grateful that in Singapore we have this formal structure where marriages are registered and then rights and obligation flowing from that can be it's there, yeah. It's so Nizam, very quickly, compared to the marriage system in Muslim marriage system in UK, what is it like in Singapore?
Dull and boring. after listening to Aina, what compares to that? Okay, so well, the thing is, dull and boring can be good because it means it's stable, it's certain, and those are the things that you would want in a marriage. You would not want to wait 30 years to find out, you know, or to question whether or not you have any legal rights. You know, like what Aina said. So the importance of the Singapore system is that there is certainty. Nobody, right, will go to the Sharia court and submit a marriage certificate from the Singapore Registry of Muslim Marriages, right, and expect there to be a dispute on the validity of a marriage. I mean, the system works, okay, because before you can register marriage at the ROMM in Singapore, there will be the interviews and then the solemnization itself, right? The person who solemnizes the marriage, he makes sure that all the essential elements of the marriage are complied with. I mean, some of the important ones would be even the wali, which is the guardian if the wife is not have been married before, right? Those are the serious factors that they look at. So and then the witnesses and everything. So in Singapore, it's quite safe. But can I just say something, right, Halija? Riding on what Aina said. Now, Aina, the experiences that you shared, actually, they do impact us here in Singapore. Halija alluded to it just now when she said she had cases where she had to scrutinize documents, right, to see whether or not they were married in UK. That's because when you want to file a divorce in the Singapore Sharia court, right, the Singapore Sharia court, and I know they are listening in now, okay, they are very rigid, right, in ascertaining the validity of a foreign marriage because it is fundamental. Because under the AMLA, right, it's either both parties are Muslims or they were married under Muslim law. And as I said, if it is a Singaporean parties married in Singapore, no issue. But if it was a marriage contracted overseas, the Singapore Sharia Court has to be very, very careful. And I'll give you a real life example of UK. It's a reported case. Anyone can go to LawNet and look it up. It's a 2007 or 2008 decision of Frida Yo Per-Chen, right, against Issa Siao. And this is a landmark case because our current Minister for Law actually was the lead counsel at the appeal. So, I mean, there's a bit of trivial pursuit. If anybody asks the question whether or not our Minister for Law has actually done a Muslim law case, he has. Okay? You can look it up under LawNet. But what was important was that the issue was the validity of a purported Muslim marriage done in the United Kingdom. Placed a bookstore in London. And Aina alluded to, you can go and walk into a bookstore, and that was what happened 2007. But I did not know Aina then. If not, I would have just, asked you for help. What do you do? But in Singapore, when I brought this case up before the judge, he was incredulous. Like, why are you casting aspersions, over what happens in the UK? You mean they can just walk into a bookstore and come up with a marriage certificate? I said, yes, those are the facts. And he looked at me like, are you sure? Okay, now I'm very assured when I hear from you, Aina. So what happened was that boy and girl, right, they flew to London, right? They went to the bookstore, but when they came out of the bookstore, they had 2 marriage certificates. On one certificate, the religion of the bride was Muslim. On the other certificate, it was Christian, right? And to cut a long story short, that was enough, right, for us to then convince the court that, look, it's very unsafe to hold that it was a valid Muslim marriage, why would they have two different certificates? Did she really convert? Because under the Singapore Muslim law, and I'll come to it, Singapore practice, now the law is that both parties must be Muslims. Only when both parties are Muslims can they marry each other. Right? So the court held that it was unsafe, and therefore the Singapore Sharia Court did not have jurisdiction. But in Singapore, one of the elements, right, is that both parties must be Muslims. But again, a bit of history. I love history, so that's why I always tend to go back. Is that in the before the amendments to UMRA of 2008, right, there was this practice, not often used, whereby a Muslim in Singapore could marry a bride if she is a person of the book, right, from the Abrahamic times. Okay. So what happened was that there was this actress in, I think, 1962 or 1964, where she applied to get married to a guy called Razak. And the court, the ROM at that time, did not allow that marriage because she couldn't prove it. Because how do you prove that your lineage goes all the way back to the person of the book? This, again, for lovers of legal historian, you'll be glad to know that the lawyer that they engaged was a certain David Marshall, right? Another landmark figure. So I know I sound like I'm name dropping like the Minister for Law and and David Marshall, but there have been all these luminaries that have actually graced our Sharia court. Okay, so don't be surprised when I say that all these old incidents, right, are now very useful when we look at it today. But now it's very clear, both parties, if you are Muslims, you can only marry at the ROMM. Can a Muslim marry a non-Muslim in Singapore? The answer is no under the UMLA, but yes under the Women's Charter. So I think Khadijah and I would have anecdotal stories, or we know people who have a party that is probably from another part of this small region of ours in Southeast Asia, where they come to Singapore and they go through a women's charter marriage, a Muslim and a non-Muslim, because they are not allowed to in their own country. In Brunei, it's a big no. Malaysia is absolute no. Indonesia is also no. So we do hear of these stories. And the the ROM, right, it will allow that marriage because it is not disallowed, to use the converse. So that's why, back to Aina, right, the issue of registration of marriage is actually very important for us, because at the Singapore Sharia Court, and increasingly, Khadijah and I will probably now have a lot more foreign clients than we had 20 years ago. I mean, I think we've got Hungarian, Norwegian, Swedish, UK don't talk, okay? There are many of them, but they come to us and they say that, look, we were married in a mosque, we were married in a house, and a lot is in a house actually, right? And I have a story of the woman who said that, oh, we were married in the civil registry at 9 o'clock, and at 2 o'clock I was brought to his house where his mother and all his family were there. 20 to 30 of them, they all dressed nicely, and they made me sign something. They made me repeat something after a person, right? And I don't know whether I'm married or not under the Muslim law. And these are real life issues that we face, and we struggle because in order for us to advise whether or not the Singapore Sharia Court has jurisdiction, right, we need to, at our end, clear this for ourselves first, whether or not the Singapore Sharia Court would hold that is a valid marriage. And sometimes it's just difficult.
If I may come in, this is what I do all the time across the world, is acting as an expert witness. They do ask me to act as an expert witness because the courts, wherever they are, accept me as the authority, and then I can say, yes, it does happen. This is why it happens. I have experience and I can give the data, and they do accept it. It's much easier if you have somebody who can verify. For example, a Syrian case under the Islamic Human Rights Organization came to me, and they said the woman was in jail, pregnant, and the husband had dumped her there, but said she's not married to me, she's committed adultery by having this baby. And she was going to be imprisoned for adultery and have the baby taken after she'd weaned the baby. And it would have been horrific, because the judge could not believe that in England this kind of marriage could take place. Don't be ridiculous. Why are you telling this ridiculous story that is unthinkable?
Yeah.
And I had to, in those days, fax. They had faxes 10 years ago. Fax my opinion to the judge for free. We can't charge in these cases. You have to help these people. Send an opinion saying it happens, it's happening all the time. I have cases daily of it. Please believe her. Just because she doesn't have a certificate doesn't mean she's not married. There should be a presumption of marriage. So the presumption of marriage principle is really important. Unless you can prove otherwise, have a presumption of marriage, because it's less human rights abuse. However, there are rights being taken by women which are abusing that principle, because they are then getting a right to financial redress, which is based on a marriage that never existed. So there is the flip side as well.
Yeah.
Okay, I know. At this point, I think I need to move on to the next topic.
Okay,
It's divorce, because there's a vast amount of information about each topic, right? So let's move on to divorce, right? So if there is a Muslim marriage in UK which is not registered, right, in the civil marriage registry, then where do this couple get a divorce? Because I understand that since the marriage is unregistered in the eyes of the civil law, they therefore cannot go to the civil court to get a divorce. So presumably they will then go to this Islamic Sharia Council or this Islamic arbitration tribunal to get divorced. So
That's correct.
It's almost like extrajudicial marriages, divorces.
Yeah.
Right?
That's why I call them quasi-legal.
And not a court of law, isn't it?
So it's like a quasi-legal structure which is being given the almost in the public's eye the status that it never had. It never actually asked for that status, but it's had it thrust upon it by the demand from the public. So if you want to have a look at the actual root of it, in a Muslim marriage contract, you must look for the right of tafweed. There's a tafweed, which is the woman's unilateral, delegated right of the law. So the woman has an equal right to give a divorce that the man had. That's in the minority 0.001% of marriages that we see. I have seen it sometimes, especially the wealthier women have it, but very seldom. So that never happens. So if she can't divorce herself, what does she do? She goes to an English court and the judge says, I'm sorry, I can't see you. You should have known better. Please leave.
Registered,
Please leave. There was a case of Akhtar and Khan recently where it got very excited. The press got very excited because the High Court, the judge, did somersaults in the air, legal somersaults, just to give her some kind of justice. He felt so horrified. So Justice Williams actually said, no, I accept that this was a legal marriage. You can go and get your financial redress. It went to Court of Appeal. It was thrown out. You can't make the law up. The legislation has to be there.
Yeah, there must be
Yeah, and it never went to Supreme Court, but I believe it would have been thrown out there as well. So when the press got very excited and started saying, oh, all Muslim women have the good legal rights now, I said it will never happen. The floodgates will not open. First of all, the judges won't follow that law. And secondly, nobody can afford it. Let's be fair. Who can afford a legal battle? So it's not going to be common, and there were no cases that followed. It just died like a damp squib.
So
what is the redress? So she can do what? She can't go to English court? Does she go back to Pakistan, for example, or Bangladesh and try and get a divorce there? No. That's not by due process because she's in England. So she has to be living in England and do the divorce. So she then has no choice but to go to Sharia Council. And that's why they've grown so hugely.
What happens if there is a foreign Muslim marriage, So for example, right, Ahmad and I got married in Singapore, right, under a proper system, right?
Please rephrase that.
And then we go to UK for, we work and whatever, and then I started disliking Ahmad intensely and wanted a divorce. So can I go to the UK courts, civil courts, obviously, right? The unitary system. And divorce Ahmad.
So is this a hypothetical situation?
Absolutely. It will
thank
never
God for that.
happen.
No, I'm saying that there are a lot of Muslims all over the world. We are everywhere, right? So
Change
we
the
got
Ahmad
married-
Ali.
We got married in Singapore, Malaysia,
Absolutely.
Egypt, etc. And then
Yeah, no.
to UK, and then we want to get a divorce. So do we approach the civil court to get a divorce?
This is very important. This is actually the critical point. The due process has to be followed. I got married in Pakistan, where I'm from, and we live in England. So what do? Lots of people in that position, because they go to their home countries just to get married sometimes, just for the fun of it, for the big bash like I did, or the families are over there. So it's a very common scenario, so we should talk about it. If you are married abroad and you've done the due process in that country, it's a formal registration process, the marriage is valid in that country, then under private international law, it will be accepted under England, under English law, which means, which most clients don't realize, you need a divorce under English law. Because that marriage now exists. Some people try and bypass it. A recent case, Hussein and Parveen, July 21, it's exactly that scenario. So if I may, I'll just give you an illustration. A couple gets married in Pakistan, marriage breaks down after a few weeks, he goes back to the UK. When it's time to do a divorce, he never sponsored her to the UK, she's abandoned in Pakistan. When it comes to a divorce, he just does a letter, which he can under Islamic law, to say you're divorced. And then he goes to the local Sharia Council to have it on a letterhead to say, yes, we accept this divorce, it's fine under Islamic law, and we'll send it to Pakistan to have it codified. So under the Union Council in Pakistan, the chairman has to accept it and then serve it on the wife. So she's got due notice and can object, okay? That all takes place. She thinks she's divorced because she received the notice. She then has a second marriage to another UK national. He also believes she's divorced. Everyone's happy. The marriage breaks down, the second marriage. And guess what? The second husband says, this marriage never existed. You were never validly divorced. I'm going to court and going to make sure this is a nullity. This is a very interesting case for you all. Now, what did the judge say in England? They analyzed the law, and it's a very important point of public policy. Otherwise, people are wandering around doing their own thing. You have to have the law which is clear. And as of July 2021, it is very clear again that marriage was valid, that divorce was not recognized under English law because he was sitting in the UK. He gives a divorce, starts it in the UK and finishes it in Pakistan. You can't do that. Either it starts and finishes in Pakistan, so that's valid, or it starts and finishes in England, and that's valid. You can't start one place, finish off another. That's important for you all to know. Okay, so make your decision which jurisdiction you want and complete it there. It doesn't mean that the second marriage and divorce is not accepted. That's still valid because she didn't know. She did it in good faith. So you can't expect to charge her with bigamy. It would be wrong under public policy. So they accepted that. However, in English law, it is wrong to try and divorce somebody abroad because it's cheaper or quicker. He just said he couldn't afford it to go to England, so he did it quietly in Pakistan. Now, men do this all the time, by the way. They come to me and they've had sometimes £60,000 legal costs fighting over this point. They shouldn't be wasting their time because the critical point is not that divorce. They should just accept the legal divorce wherever it is in the world. The critical point is, are you allowed to use that to bring a financial rights application? We should talk about that. And yes, you can. In England, you can rely on a foreign divorce, which is valid, to bring an application for financial relief in England.
Aina, I need to, we'll talk about recognition of foreign divorces in UK later, but I need to go to Ahmad Nizam now to ask him to briefly explain, how Muslim divorces are handled in Singapore, because we've done the situation in UK, which from what we gather is very, very problematic. So Ahmad, very briefly about the divorce situation in Singapore.
Oh, okay. Very briefly, I think the first thing that you have to look is the jurisdiction and the powers of the court, right? So, in terms of jurisdiction, Section 35 of AMLA, right? Either both parties are Muslims or parties were married under Muslim law. And as I've said, increasingly we are seeing foreign couples, right, seeking the jurisdiction of the Sharia court. And so, as I said just now, the Sharia court will ask parties to give evidence through a form of affidavit on how the marriage took place. And oftentimes, if it was very long ago, it can be a problem for parties, right? Because I know, although you said that a lawyer can give an affidavit, an expert opinion, that is a secondary tool, right? The first tool would be if the imam is still alive, the witnesses are still alive. Those are the witnesses of fact that they can give evidence. Then what normally happens is that you can then get an affidavit from a lawyer of that local jurisdiction to verify that these are all in compliance with the local laws. And you have to do that. For example, if you have chosen, even if you're Singaporean and you have chosen to go and marry overseas, there are Singaporeans who do go over to Batam, who do go over to Golok in Thailand, right, to get married over there, simply because they will refuse, right, the permission to marry in Singapore. For example, right, he may want to enter into a second or third marriage, polygamy, right, which is valid in Singapore, but the criteria is very strict. So if the man has been rebuffed by the local registry of Muslim marriages, don't be surprised. They just tell the girlfriend, let's just take a flight to Thailand, and then they go all the way down to Hadai or Golok in southern Thailand, and then they spend I tell you, they have their sources. They can just know where to go, and they will come back with a marriage certificate from little villages in Thailand or in Indonesia. The problem will be whether or not then, right, those certificates, sometimes just a piece of A4 paper, will be recognized. But the thing is, they don't think through. Okay, so they just want it because they want a piece of paper to say they're married. But when it comes to divorces, it becomes a big problem, a very big problem. And then sometimes it goes through because in Singapore, if you want to apply for public housing, you have to prove that you're married. Anecdotally, we know of cases where the housing board have approved their applications. But later on, when it comes to divorce and all these issues arise, the housing board also takes a back seat and said, you guys go and sort it out yourself. But it gives us a lot of problems. So in a nutshell, if both are Muslims, married under Muslim law, you go to the Singapore Sharia Court, and the Singapore Sharia Court will have the power, right, to make ancillary orders on nafkah, eda, and muta'ah, which are financial settlements, right, for the length of the marriage, for short maintenance, on the children and on the assets. Right, but and this is very fundamental because Harita will go into it much later on. Is this the Sharia court under AMLA can only exercise its power when it has jurisdiction. Okay, I know it's legal gymnastics, but there will be situations later on where the Sharia court will say we have no jurisdiction to hear your case because you are already divorced. If there is no divorce application, the Sharia court cannot exercise that power. You will have to go to the civil courts under the Women's Charter for that. But I'll stop there because I think Hadi that a lot of other issues.
Yes, I need to ask Aina now with regard to foreign divorces, right? So, a UK national, right? They got married in UK, whether registered or unregistered, and then they move out of UK and then live abroad, and then manage to get a divorce in a foreign jurisdiction. So, how does UK look at it? Yeah, is it recognized? And if it is, what is the basis for recognizing this foreign divorce? They are UK
Okay.
nationals, yeah? And then after living
Yeah.
abroad, getting a divorce, and they go back to UK. So will that foreign divorce be recognized in the UK system?
So under the Part 3 of the Matrimonial Act 1984, you are allowed to rely on a foreign divorce to get financial rights in the UK, but you have to prove that it was by due process. Okay, you can't just turn up with an A4 piece of paper saying it's a divorce. So how do you do that? It's section 46 and 46, A and B, very specifically, and very, very difficult. You have to prove very simple things like, was there notice given to the wife? Due notice that you can prove. Yeah, I told her it's not good enough. For example, the chairman of her local union council, a registrar, has to serve her. Sometimes they throw it. When it's not being accepted by the wife, the courier throws it over the garden wall. You know, it's accepted because you can prove it was going over the garden wall. So it's very specific. If the wife was given notice and she ignored it, you will still be allowed to get a divorce. It has to be in writing. It has to have enough time period for her to be able to complain that it was invalid. So once all those things are satisfied, due process has been followed, the English judge will accept that divorce. Other things matter, like nationality, like habitual residence. So if the couple were in purporting to be abroad while they had that divorce, but really had flown back, were living in England and just pretending to do it by post, which they do often, then that won't be accepted. You look at when they were in the country. So we prove flight tickets and conversations. Yes? So you have to be in the right place at the right time to be able to have a valid divorce.
So if the UK courts recognize the foreign divorce, can the parties make a claim for ancillary issues like children, maintenance, division of matrimonial assets, whether the
Yes.
assets are in UK or outside UK?
So under the Part 3 procedure, yes. So you take your valid foreign divorce, you make an application under Form A under English law in the usual way, as if you had an English divorce, and the whole raft of procedures is available to you in the normal way, and not only the assets in England and Wales, but worldwide.
I will
The
now
judge can bring them all.
Ahmad, what is the situation in Singapore, right, with regards to foreign divorces? How is it treated in Singapore Sharia Court, in the civil court? Yes.
Okay, right. So if you, sorry, not you, okay. So if a couple have already obtained a divorce in a foreign country, right, and we're talking about Muslim couples, right, then you cannot go to the Sharia Court of Singapore, because this is all the way back to Muril Shah's case in 1990. Since the divorce application, the Sharia Court does not have the forum, or it's not the forum to exercise its powers. But let me put it. What is happening today is this. There is a famous case called TMO that I think the Singapore practitioners would be familiar with. It was just a couple of years ago. Now, in that case, parties were divorced in Johor, which is just across the causeway for us in Malaysia. But the wife subsequently filed for divorce in Singapore, and the Singapore Sharia Court, right, held that no, we cannot hear your ancillaries because you're already divorced, and so therefore there's no power. But we can make orders on the small financial issues of nafkah ida and muta'ah, because they rely on a historical provision. Because in the past, when people were divorced outside the court through the qadi, right, or qazi in some countries, right, they could go to the Sharia Court just to get ancillary orders. But where the divorce was already done by a court overseas, then it cannot be done. Now, what has happened, therefore, that parties then went to the family court, and then the family court held that they did not have the powers to make any order because they are Muslims. And he went to the High Court, and the High Court also said, no, we also don't have the power because it's not provided for. And then they went to the Court of Appeal, and then the Court of Appeal said, aha, there's this thing called a residual jurisdiction, whereby parties in Singapore, right, even Muslims, you can rely on the residual jurisdiction of the court, because otherwise the parties do not have anywhere to go to resolve their ancillary issues. Now, but what I'm going to say is this, and there have been a couple of cases since then, is that I think it's time for a review, because there could be another way to solve this issue. Is it by importing a provision in the Women's Charter which says that the Family Justice Court, right, they have the powers to make ancillary reliefs where the parties have been divorced overseas. I mean, personally, I see that there's no reason why you cannot give the same powers to the Sharia Court. And I say this because it would be practical. Because in the case that I mentioned just now, you have a situation whereby they can go to the Sharia Court, but the judge can only make orders on nafkah, eda, and muta'ah. Then he says, oh, with regard to the children and to the house, you got to go to another court, which means the High Court or the civil courts. And so it's another round and another round. Now, if it was the same judge listening to all the issues, right, surely he can take into account the nafkah, eda, the muta'ah, together with the issue of the assets. Okay, but because the TMO case was a decision of the Court of Appeal, and maybe it's held that it's too recent, so I await and see whether there will be a legislative change to this. But maybe for the benefit of practitioners, you can read a case called UJM, which was just released a few weeks ago. This is the decision of Justice Wubili. I think it's Justice Wubili, right, Alida?
Yes.
That went out in appeal in the family division, where the parties were divorced in a Pakistani court, right? And then again, they had to go to the Sharia Court in Singapore just to get the claims of nafkah eda, the 3 months maintenance, and muta'ah, which is a consolatory gift. But then they had to go over to the Family Justice Court, imagine 3 different courts, just to rule on the assets. And this is when the parties got a bit naughty, because then they started to raise the issue, oh, maybe the Pakistani divorce is not a valid divorce. You know, Aina, you just reminded me of it. But the Justice Wubili was having none of it. Okay, he shot it down very, very forcefully, and he said, look, if you say that the Pakistani divorce should not be recognized, go and do something about it in Pakistan. Go and set aside the order in Pakistan. Don't come to the Singapore High Court and then tell me, oh, you know, I think the divorce in Pakistan is not a valid divorce. Because how can and he said that it would be incongruent for the Singapore High Court therefore to say that your divorce in Pakistan is not valid, and yet there is a live divorce in Pakistan which says that it is valid. It just doesn't make sense, right? Especially the Committee of Law. So I thought that was a very sensible direction given by Justice Wubili. And people take note, don't play games with the court on this. They frown upon them. Yeah.
Aina and Ahmad, it's almost 4:20 now. I think I will stop the two of you talking. It's very, very interesting, and I think it's endless. However, I think it's time to take some questions, and there's some questions, yeah? So the first two will be for Aina. There is a question here. There is no requirement to register the Muslim marriage in we're talking in UK, yeah, in the civil registry, but are they forbidden to register the marriage in the civil registry? Aina?
No, absolutely not. The default position should be that they register. The government expects them to register, but that does not happen. They're not forbidden. They're encouraged to do it, but they would have to do either 2 ceremonies. One is the nikah and one is a civil registration, or they would have to find one imam out of thousands who's willing to have registered himself to officially perform the civil as well as the nikah marriage. So it's very rare to find that person. Or they would have to go to a restaurant or hotel which is registered to perform civil marriages, but has also got the imam attending. So in one function, they're having both things done. There are many ways to do it. Many people now, this is very important to tell you, they're deliberately not registering. They're fooling the weaker person. The power imbalance is so great that either it's the husband or the wife who says, I've got something to lose from having a legal marriage.
Yeah.
And it's not even the couple. Sometimes the in-laws get involved and say, you will not marry her until I have tested the marriage. I, the mother-in-law. Has she been good to me? Has she given me a grandson? All those Neanderthal viewpoints are now being allowed to take place. The pre-Islamic Jahiliyyah is alive and well in the UK. So
Yeah.
women are rewarded sometimes, very seldom, but rewarded years later with a civil marriage if they behave well. So there are all kinds of shenanigans going on.
Because there is no legislative requirement to
Yeah.
make it mandatory, right, for the
Absolutely.
marriage to be registered. So that's the situation. Another question for you, Aina, before I go to Ahmad. Question is, for a Muslim couple, if they have a Muslim marriage, the nikah ceremony, and they then register the marriage in UK under the civil marriage registry, question is, if they were to divorce, the court there does not apply Muslim law, correct? I think.
Absolutely.
Yeah, Aina?
There is no Sharia law in England and Wales and Scotland. So the judge cannot, even if they wanted to. However, the way I do it, I do apply Sharia law. When it's more equitable to have Sharia, for many women, it's more equitable because they've got no rights under English law, but they have a huge amount of rights under Sharia. I use the aegis of English law, and under that umbrella, I create a solution under Sharia. And for example, I use English contract law to make sure the meher is enforced. And the English judges have been amazing. They have listened. We don't have any reported case law yet because the men always give in when under severe pressure or under mediation. So we've never had a man who fought all the way and then be able to have a reported case. I have one that may be reported. I'm waiting to see because he's fighting all the way.
Mahar, which is referred to by Aina, is like dowry, yeah, the marriage dowry. So
We don't call it dowry because that's given from the husband to it's given from the woman to the man. So that's the dowry. The nearest equivalent is the dower, D-O-W-E-R, which is
from the husband to the
given
wife.
from the husband to the wife. Yeah.
Okay, Ahmad, a question for you. If a former Muslim renounces Islam, would Sharia law and the Amla still apply? I think there must be a context to this question.
Yeah, I think he's asking about where parties were married and then one party subsequently renounces the religion. Actually, the answer to the question, right, was given by the Minister for Culture, Osman Wok, in 1966 at the tabling of the Amla. It's in Hansard, okay? When the Amla was enacted in 1966, it was tabled. I clearly remember a quote by Osman Wok, and he said that prior to the Amla, right, that it was not stated whether or not that the Sharia court would have power if the parties had been married under Muslim law, and that was why Section 35 was worded in that way, right? The or, right, and not and. Remember, it's both parties are Muslims or they were married under Muslim law. I have always been curious as why it was an or and not an and until I read the Hansard and it said in 1966, and that's the explanation. Because to cover that position, that if they have been married under Muslim law, it doesn't matter then, therefore, if you subsequently renounce, because Section 35 covers that scenario. And we have had cases on this, right? I think, Khadija, you had very landmark cases on this issue, so maybe you want to check in with your own case on this. Yeah.
Another question for you, Ahmad. When parties marry under women's charter, i.e. a Muslim and a non-Muslim spouse, yeah, because they are allowed to marry under women's charter in Singapore, yeah, Aina. But one party, can the Muslim party insist that the divorce proceedings be filed in the Sharia court?
No.
It's obvious. Go on, yeah.
Yeah, same answer. The answer is clear cut. No, they got married under the Women's Charter. They have to get divorced under the Women's Charter.
Yeah, you cannot jump around, think that you get a better deal in the Sharia court.
We call it forum shopping.
Yeah. Well,
you cannot do forum shopping.
Well, I think the old timers like Halija and myself, we do remember cases in the 1990s, right, Halija? There was a spate of cases where actually parties got married first under the ROM, under civil, and then subsequently they got married under the ROMM. Remember? There were a spate of cases. And then what do you do when they wanted a divorce? And then they went to the Sharia court to get the divorce because there was a Muslim marriage. And then the problem was, then what becomes of the civil marriage? And for many years, it was a very grey area. Lawyers actually went to court and applied for a declaration in the High Court to expunge the marriage, to declare it null. But the High Court said, no, they entered into a valid civil marriage. You cannot expunge it. You cannot say that it did not exist. It did, right? But I think some years later, there was a Justice Tan Liming decision, right? Where then he said that by getting a divorce at the Sharia court in Singapore, it automatically dissolves the civil marriage as well. Because it's the same two parties that we are talking about. And that has been the case law that we have relied upon. And that saved us a lot of problems in having to apply again to another court to get declarations. Yeah.
Aina, a question for you. Do Muslims married abroad, presumably they are UK nationals, yeah, have to get their marriage recognized in UK before they are able to get a divorce?
No. So if you have a marriage certificate from abroad, you do not need anything recognized by the registrar. Again, you are married. You can take that marriage certificate to the English divorce court, and many do, and it's accepted.
Let me see whether, I think there is another question for you, Mr. Ahmad. Nizam, there's a question for you. It says, it asks here, I think it's question 7. Can you explain how is Malay custom used in dividing matrimonial assets, as the old 30% rule on harta sepencarian no longer seems relevant, as more cases seems to be using the structured approach? I think you have to do this very briefly because it does talk about the jurisdiction of the Sharia court. So
yeah, and I think the person who asked this question must be very naughty. Because see, the problem is this, because I think that's why a bit of legal history is important. We must remember when the AMLA was drafted, the context in which it was drafted, right? When the late Ahmad Ibrahim drafted the AMLA, he took cognizance of what was happening around the region, right? And in the region, in the whole Southeast Asia, we had in Indonesia and in Malaysia, different customs being applied in the various courts in those countries. Now, but you see, even in Malaysia, every state has its own Sharia court. And every state, if you speak to Malaysian lawyers, will tell you that over the years, it has evolved, that the Malay customs have sort of decreased over the years as the body of case law has come out, have evolved, and we are now very clear as to what are the principles that we want to apply. So, to be very honest with you, today in 2021, if you want to write on the case in the Sharia court and say that, oh, I want a strict interpretation of this and you must apply the Muslim customs, I think it will be a very uphill burden because they were there, they were provided for in 1966, right, in the circumstances that we were in at that point in time. But today, if the body of case law is so clear, these are the principles that will be adopted. And in the division of assets, in section 52(8) of the Sharia Court, and it's a long, very exhaustive list of the factors that will be taken into account, you will have a tough time to convince the court why we should use the Malay customs, right, on top of to set aside all the factors under section 52(8) for the benefit of those who don't practice the Sharia Court. That's in pari material with 112 of the Women's Charter, right? So that's my short answer, Halija, because I don't think it will take too long. I will go too much into history. Yeah.
I think our time is coming to a close. We started 5 minutes late. Do I get an extra 5 minutes in fairness? Yes or no? if not, I think we should close now, and it leaves me to thank our two eminent speakers, Aina, early in the morning in UK, and also with some personal private issues, yeah, and of course Ahmad Nizam. And with that, I will close the session, and thank you for staying with us, and stay safe, everyone. Thank you.
Thank you.
Thank
Bye-bye.
you. Bye-bye.
Thank you, ladies and gentlemen. Thank you for the panel, really, to the panel for a very interesting, very sort of vibrant discussion, which wandered around but touched on so many interesting parts. Ladies and gentlemen, we now come to the last